Did you enter the US without inspection and now have to apply for a waiver in order to get a green card through your US citizen or permanent resident spouse? In this video, I'm going to tell you all about the I-601A waiver, how it can help you get your green card, even if you had unlawful presence in the US, what type of documents you need to show extreme hardship, and what the processing time is like so that you are prepared for this waiver. I am U.S. Immigration Attorney Lillian, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. An I-601 waiver is for people who have unlawful presence in the U.S. and have to leave the U.S. for their visa interview. Who is the I-601A extreme hardship waiver for? It's for people that have unlawful presence in the U.S. and must leave the U.S. to get their green card at an embassy. So if this is you, then this video is for you. Let's talk about the waiver. In order to get an I-601 waiver, you have to show extreme hardship to a qualifying relative. In this context, a qualifying relative is either a U.S. citizen or permanent resident, spouse, or parent. That's it. U.S. citizen or permanent resident, spouse, or parent. Children do not count for an I-601 extreme hardship waiver. Okay, only spouses and parents that are U.S. citizen or permanent residents. Now, here's where it matters when it comes to your visa interview. If you have to leave the U.S. to go to a visa interview in order to get your green card, it's going to be a problem when you have unlawful presence, because if you have stayed in the U.S. for 180 days or more, but less than a year, right? 6 months or more, but less than a year, and then you leave the U.S., you are banned from applying for a visa, getting a visa to the U.S. for 3 years. 3 years. Now, if you stayed in the U.S. for 1 year or more, unlawful presence of 1 year or more, you are going to have a 10-year bar. So remember, 6 months but less than a year, you're getting a 3-year bar. A year or more, you're getting a 10-year bar. So that's why this waiver is so important, because remember, if you entered without inspection, you must go to your interview at an embassy, which means you must leave the US to go to your interview. And the second you leave the US to go to your interview, if you're over 6 months but less than a year, that's 3 years bar. If you are over a year, that's 10-year bar. And without this waiver, the embassy can't actually give you a visa. So that's why it's so important that you know whether you are fitting into this, right? Let's talk about the waiver. In order to get an I-601 waiver, you have to show extreme hardship to a qualifying relative. In this context, a qualifying relative is either a U.S. citizen or permanent resident, spouse, or parent. That's it. U.S. citizen or permanent resident, spouse, or parent. Children do not count for an I-601 extreme hardship waiver. The beauty of the I-601A waiver is that it waives the 3-year and the 10-year bar, so that when you leave the U.S. for your interview, you can actually be issued a visa and you can actually come back to the U.S. Now let's talk about how to show extreme hardship, because sometimes people hear extreme hardship and they're just confused. I'm going to talk to you about 3 ways that you can show extreme hardship and what kind of documents to include with your I-601A waiver that will help you show the officer that this is extreme hardship. Extreme hardship is not, we're going to be separated, I don't want to be separated, let's, give us this waiver. That's not extreme hardship, because if you think about it, every single person that has their spouse in another country and is applying for their spouse to come to the US is in the same situation, right? They are suffering separation. So separation alone, USCIS has actually said this, separation alone, having family separation is not enough for an I-601A waiver to be approved. And that's the key here. Extreme hardship is not just we're going to be in different countries, it's so hard to be in different countries. That's not extreme hardship. Extreme hardship is something more. And I'm going to talk to you about 3 ways that you can show extreme hardship. And they are health and medical hardship, financial hardship, and educational hardship. Medical hardship is where your U.S. citizen or permanent resident spouse or parent has a medical condition that is serious. So these are conditions that could be made worse by your absence. So if you are the caretaker for your parent or your spouse that has this medical condition, and you are the one that makes sure that they get to their appointment, that they take their medication, that they stay on top of their health needs, that is good. Those are things that will be worsened if you were not here to do it for them. If you are not here to take care of your parents, now your parent will have to pay someone to take care of them, which will be a financial hardship on your parent. We're gonna get into financial hardship, but I want you to start thinking about how everything connects, right? Everything connects. Now, medical hardship, let's stick to it. Your spouse, your parent may have a medical condition that requires them to have certain types of treatment. Those treatments might not be available in the country that you're from, right? Or might not be readily available in that country. Some countries don't have health insurance like the US, and if you have to pay for everything out of pocket, that's going to be an additional expense that you may not be able to afford. So it's so important that you are documenting not just the medical hardship, how it's going to look for the person in the US if you were to leave the US, but also if they were to go with you, what would that look like over there, right? Are they able to get the medical treatment they need? Are they able to get the medications they need? Are they able to get the, whatever else they need for their medical condition? Are they able to get it over there? And if the answer to that is no, that should be going in your extreme hardship waiver, right? Evidence of it should be going into your extreme hardship waiver packet. The next thing to pay attention to is, of course, children, right? I know I said that children do not count for the extreme hardship waiver because they are not qualifying relatives. However, if you have children that have medical conditions that your spouse will now have to be the sole caretaker of, the sole financial provider for the family, and also the caretaker for the children, and make sure that they go to their medical appointments, that they do all those things, that can be a hardship to your spouse based on your children having a medical condition. Let's talk about financial hardship because I've mentioned it several times. So let's talk about this specifically. When it comes to financial hardship, you are showing that either your spouse, that's the foreign national, is the breadwinner, right? They're the ones that work. They're the ones that, take care of all the finances. Or the U.S. citizen is the one that works, is the one that takes care of all the finances. But the non-U.S. citizen is the one that takes care of all the household needs, right? They take the children to school. They take the children to their medical appointments, make sure they take their medication, make sure that everything in the household is taken care of. And the spouse, that's the qualifying relative, all they're really doing is providing financially and making sure that the family is taken care of financially. They're not involved in the day-to-day having to schedule appointments, having to go to appointments. They have their non-U.S. citizen spouse taking care of all of that. And now they have to do it all. Now they have to do not only their own going to work, providing financially, but also making sure to take care of the kids and make sure they get to their appointments and do all of that, that's going to be hard. So when you think about hardship, everything is connected. I'm just going to keep saying that. Everything is connected. Now, financial hardship, how do you show it? You show financial hardship by showing your expenses. We have this thing, we have a financial chart that we include with every single I-601A waiver, where we list out what the monthly expenses are, right? What are the bills? If there's childcare, if there's medications that need to be paid for, we make sure all of that is included. Then we also include additional expenses if the non-US citizen was going to leave the US, right? So these are the normal monthly expenses, but these are additional expenses that we're going to have if my spouse is to leave the US. So that can include childcare, because before maybe your spouse is the one that, took care of the children. You didn't need childcare. Now you're going to need childcare because you can't work and take care of the kids at the same time, right? You really have to think about this stuff. Financial support, if your spouse is not in the US and is not working, you may need to provide them with financial support. You may need to be sending them money. And you may want to go and visit your spouse when they're outside of the US. What are those tickets looking like? How much does it cost to actually, for you, if you have kids, for your kids, everyone to go and visit your spouse? What does that look like? Another aspect of a financial hardship is, let's say the spouse, everyone goes to the home country, right? Your spouse, your children go with you to your home country. What is the likelihood that your spouse will actually be able to get employment in your home country? Do they speak the language? Do they understand the culture? Do they have marketable skills that they can easily get a job over there? Educational hardship is where, let's say, for example, you yourself or your children are in school. The U.S. citizen or permanent resident spouse is going to have an emotional hardship if their children are not able to get the education that they know that the children deserve, right? They're in school in the U.S. They're getting great education in the U.S. They may be moving to a country or a region in a country that's like rural and don't have the educational capabilities that where they live in the US has, and now they have to start over. The children are in schools, they may not speak the language, they may not even be able to cope over there. So all those things matters. And in most countries that do not have a free education system, you have to pay for the children to go to school. So that's an additional expense that they would not have had in the US. So when I say that the medical, the financial, the educational, every single thing flows together to work to show this extreme hardship. So do not just focus on one aspect of it. Really think outside of the box, right? If there is a medical hardship, there usually is within that medical hardship some form of financial hardship. Okay, so really think about it. Let's say the kids, an educational hardship can also be tied into a financial hardship or a medical hardship. If the kids are in school and they have some form of learning disability, they have IEP, and you take them to a school in a rural area in another country and there's no support for the kids, that's a hardship, right? Yes, the children are not a qualifying relative for the waiver. However, that's going to be very difficult for the U.S. citizen or permanent resident parent to watch their children suffer, where they're not getting the support they need, and they know if they stayed in the US, they will have that support. That's a hardship. So everything literally works together to create an extreme hardship waiver packet. Okay, you want to document everything. So if you're saying that your spouse earns $50,000 you need to document that. If you're saying that your yearly expenses are $100,000, you need to document that. If you're saying that there's medical conditions, you need doctor's notes, medical records, everything, right? List of medications. And if you can include how much they cost too, right? Education. If the kids have IEP, you need to document that. If they have any medical conditions, document that as well. Letters from their doctors. What will happen if they do not get the treatment that they need? You want to paint a picture for USCIS to be like, listen, this is not just separation. I am not just worried that I will not be able to see my spouse every single day. That's not what this is about. This is about the extreme hardship that me and my family are going to go through if this waiver is not approved. If they are not allowed to come back to the US, our lives are going to be horrible. Once you have all the documentation, you want to go ahead and write a detailed statement. So a statement basically tying everything together. On your end, what would your life look like as the US citizen or permanent resident, parent or spouse? What would your life look like with or without your spouse, with or without your child, right? That's what matters here. So you need to be very detailed. Sometimes I have my clients do psychological evaluations because I want to document what would this look like for the entire family, right? For the spouse that's going to have to leave the US to go to an interview, for the spouse that may have to stay here, for the spouse, for the children, for the parents, whoever is involved. We want to get a picture. And sometimes a psychological evaluation is your best tool. You need to document everything because that's the only way you can win. If you have found this video helpful, hit the like button and tell me in the comments what has surprised you so far about how to show extreme hardship. Now let's talk about the part that everyone wants to know about. How long does this whole thing take, right? I know I have to file an I-130, and then once that's approved, I filed the I-601A waiver. But how long does the I-601A waiver take? I can tell you that those are taking about 3 to 4 years. USCIS is trying to speed those up, but as of today, they're still processing cases from 2020. Those are the ones being approved right now, are cases from 2020. So hopefully they end up catching up. There is a lawsuit going on because of how long these are taking that is probably going to put a fire in USCIS behind to get these cases moving along. So we do expect them to be moving faster than previously, but right now it's still taking 3 to 4 years, unfortunately. But remember, the goal here is that at the end of this whole I-601A process, that you are getting an approval and you are able to travel for your visa interview, do your biometrics, all of that, go to your interview, be approved, and be able to return to the US. Because once you return to the US with that visa, you are now a permanent resident. But you're not able to get to that visa interview if you do not have the I-601A waiver approved, which is why it's so important that you pay attention to the 3 ways that you can actually show extreme hardship. If you are over there wondering how you can make your particular situation fit within an extreme hardship waiver, what documents to include, what to do, how to go about it, well, you don't have to go through this on your own. I'm a U.S. immigration lawyer and I help my clients do this all the time. So if you want help with this process, if you want to see if you qualify, go ahead and schedule a strategy session with me. You can go to my website, Lillylegal.com, and click on contact us, and you can actually pick a time and a date that works best for you. And we can get on a call and see what the best way to help you is.